at section 7, you had proprietors of butcheries, abattoirs. Those are people who are privileged under the Act. And you're licensed to carry a specific firearm and a specific number of ammunition. So the licensing body, you all know, is the Firearms Licensing Board, whose representatives are here. So you've met Chengo, you've met Munene. That's where you apply, and there are some of the people who consider. Now, briefly on the role of Ngao, why we are really here, is an association to promote responsible firearm, use, to promote efficiency and proficiency, and above all, to enable members interact. So the role of Ngao is something who you know the role of Ngao. And more importantly, they've now facilitated this particular course to enable you understand what we're actually discussing in terms justifiable use of firearms. So the role of Ngao is also very, very important, and you'll see that if you're a firearm will be undertaken is a threat to life, security, and the right to property. So as a firearm holder, what are your obligations under the law? 1, ensure you are properly licensed, because if you are not properly licensed, you cannot now claim that is a justifiable use of the firearm. It's like you go to where people buy those AK-47s, and you buy one or you buy a pistol. You are not a licensed firearm holder. A licensed firearm holder is one who is registered and permitted under license to carry a firearm. The only exception would be policemen, military people, etc., who've got special exemptions. So you must ensure proper registration and proper certification, because if there's an incident and you don't have proper registration, proper certification, you will not be able to avail yourself the defenses which are available to you at law. So you must also ensure proper storage and proper custody, because if you lose a firearm, I can tell you that's one of the biggest headaches you'll ever have in your life. When the shit hits the fan and you lost that firearm, let me tell you, you'll not be able to sleep. So be very, very careful, ensure proper storage and custody. And then when it comes to carriage, make sure you carry it in a way that is not intimidatory. Concealed carry. You're not allowed to probably say, brandish your gun or, show it, around your waist. Then one other thing is that you should avoid illegal transfer. If you have to dispose of that firearm, it must be in accordance with the law. So those are obligations of a firearm holder. I now move on to tell you in what circumstances your rights can be limited. Like all rights, you have rights and obligations. things that we have probably think as members of Ngao, whether we want regulation in that particular regard. Now, the other comparison is United States of America. I think they have got the most liberal gun laws under the Second Amendment. They consider that to be a right. So licensing depends from one state to each state, and registration will depend on the kind of sport you want to undertake, whether you want to use it for personal protection, sport, etc. I say they are very, very liberal, even in terms of open carry. Now, the next thing I want to deal with is the topic which you know has brought us here today, which is defenses and justifiable uses of firearm. 8. You are entitled to actually use the firearm to defend yourself, or to defend your property, or to prevent attack on your family. But that said, it's not every instance that requires you to use actually a firearm. So certain principles are actually being developed. In what circumstances would you be allowed to actually use your firearm? There must be imminent requirement. You're facing a danger, somebody has got a gun, somebody has got a panga. At what distance did you see this particular person is 100 meters away? Is it justifiable to pull out your gun and shoot at that particular person if you're under attack? If somebody's got a panga or a penknife or has got a walking stick, are you justified in taking out your gun and using that particular firearm? So there's, because at that particular point it is subjective. What is it that you're seeing? What is it that is threatening you? What is it that is threatening your family? Those are all instances that you must look at. And one of the famous cases in South Africa involving Oscar Pistorius, you remember the gentleman who was running on blades, and he decided to shoot through the door, and the girlfriend was actually in the loo, and he actually set up a defense of self-defense. So at the end of the evaluation of the evidence, it was found to have acted in a manner that was contrary to proper gun use, and he was actually convicted of murder, I believe. Because what he did, he said, I had some people in the house, I went, I had some commotion in the toilet, and he shot through the door, and the girlfriend was actually in the toilet. So you must weigh in what circumstances you want to use your firearm. If you just see some movement or you hear some movement, you need to find out exactly why that movement is there and who's really there. Otherwise you'll end up shooting your own, family member. So eminent does not necessarily mean you must use it. There must be necessity. So you should not generate that necessity yourself. So other than imminent threat, you must ask yourself, is it really necessary for me to use that firearm? So imminent threat and necessity go hand in hand. Now in law, necessity provides two approaches. In some instances, somebody could come and attack you in your own house. If that particular person is outside your house and you're inside your house, it's a different situation whereby, say, you're out on the street. Because you have a right to protect your family. If that particular person is threatening you and is trying to get into your house, that could provide a totally different circumstance as if you're out on the streets. So the law recognizes some instances where you are allowed to stand your ground and repel, for example, burglars breaking through your door, cutting through the metal grills. One would understand if you shot those particular people. So the stand-first approach is founded on the individual's right to bodily integrity and autonomy, though it's arguable that this approach most readily recognizes that defenders are often required to act instinctively in dangerous situations He's been criticized for ignoring the attacker's right to life and physical security. So along with that, we have something called the safe and retreat approach. If, for example, somebody attacks you and you're able to actually retreat, the law will ask, why is it that you had to actually engage if you had an opportunity to retreat? I gave you the example of somebody who's 100 meters away and somebody who's probably, say, a meter away from you. Those are totally different circumstances. So the case, an example of safe and retreat is where safe retreat approach was applicable in Kenya but not used in the case of Republic versus Dixon Mwangi Munene and another. Now you remember this particular case where the son of the former Assistant Minister, Patrick Mwiruri, was actually killed. What happened in that particular case is that they had a kind of an exchange in a club. They were upstairs. This particular person left that particular person upstairs, went down, picked up the firearm, went up and shot the son of Munene. But this guy could have just walked away. Why did he have to take the gun and go back to shoot that particular person? So that defense fell through because this guy had an opportunity to actually retreat and drive away. So there is a Kenyan approach towards the necessity requirement. Although there is a clear distinction as to the safe retreat approach and the stand-fast approach on personal self-defense, the majority of common law jurisdictions like Kenya favored a less structured compromise approach to the issue of necessity and retreat. This involves the necessity rule being subsumed under the broad umbrella of the test of reasonableness, where retreat is not considered compulsory, but merely a factor to be taken into account. So the case to read is the case of Mungai versus the Republic. Then I talked about proportionality. Proportionality is about balancing forces. If somebody attacks you with a walking stick, do you have to shoot him? If somebody already running, do you have to shoot him in the back? If you can repel or even fire a warning shot, those are major considerations when it comes to a defense of an individual. So I've given you the proportionality test requirement. Now this particular PowerPoint presentation will be available to you. You'll have time to read. Now I want to move on to the next issue, which is public defense. Is also an area where one is allowed the legitimate use of firearms. For example, policemen. Policemen can shoot you in some particular instances, but as we have probably experienced, they are also coming under siege. It's not all instances where a policeman would walk scot-free. Take, for example, the case of the Gen Zs and the people who are actually, protesting and rioting towards Parliament. And you had snipers on top of KICC and other buildings bringing down these gentlemen. I don't think they would be able to defend themselves if at all they were actually arraigned in a court of law. So on arrest, a policeman can actually use the firearm. You've had instances where people have resisted arrest, and you have that common phrase that policemen use. I commanded the person to stop. What did he do? He defied my order, took out a firearm. I responded and shot and killed the person. So don't be in that particular situation. So in prevention of crime, the policemen are actually allowed to use firearms. Then one other defense is provocation. That is defined under the Penal Code. I've given you the definition there. Now, provocation works both ways. You have the attacker and the person who's being assaulted. You're walking on a Saturday morning, and then this guy's on a motorcycle, come around, probably take your phone and threaten you in such a particular case, you are provoked into action. You can defend yourself. But if it was the other way around, that you're the one who's carrying the gun and you're actually probably threatening somebody who's on a motorcycle, it could be provocation on your part. So it also depends on the factual situation. Provocation is two ways, and it will depend on the circumstances of each case. Now, there is also the issue of duress as a necessity. Duress applies where a person's choice is constrained by threats to do an act that would otherwise be a crime. A typical case involves the defendant being told to do this, or else you or a member of your family will be killed or seriously injured. So I imagine a situation whereby somebody tells you, do this, or else I'm going to kill you. You're two people in a room. You're told, look, please, shoot the other, or else I'm going to shoot you. It will be a good defense if, let me say, you know, you are in a court of law, and you say, look, I was threatened to do this, but that defense would not hold in the circumstances. Why is it that that particular person is to die and not you? So once again, the circumstances of the case will depend on what you are trying to say. So I conclude by telling you the case that has dealt with the issue of duress and necessity. And Lord Bingham, in the case of Hassan, said there are limitations to the defense of duress. The threat or danger must be of death or serious injury. And the threat must be directed against the defendant, his or her immediate family, or someone else close to the defendant. So, gentlemen, I want to thank you. We've now reached a point where now you have your firearm. You've complied with every legal obligation towards keeping it safe, using it. You have the right ammunition. You are in a legal carriage, and therefore now shit's the fan. So we have instances, for example, like our friend who was in Mombasa. There is a riot. He's defending his cafe. Shoots somebody. You have a case. He goes into a club, shoots somebody. So I'm handing over that to my learned friend to now deal with that particular situation, and we'll be able to actually, have an interactive once, we've already had the presentation. You have a question? Yes, please.
Thank you, Counsel. The question I have is, this fellow who was at these places where they treat guys with not very good thoughts, and the guy gave his firearm to somebody else who shot, and then he ended up being the one to be prosecuted. How about that?
I think we'll be able to deal with that specific case as an example of what the law requires you to do. First of all, there's the issue of safekeeping. Why is it that the guy handed over the gun to somebody else? Was it a case of negligence? You are liable. If your firearm, say, is used by somebody else, how did that particular person get access? That is a very, very common issue, especially, amongst policemen. You find, they carry the gun home, they go home with it, they put it in the drawer, not in a safe, and then you find either the child or the son has taken the gun and actually shot somebody. So there are several offenses which my learned friend is going to deal with. So let's have that discussion once we've already had that presentation.
Thank you. Round of applause for Senior Counsel. Asante sana. Moving on swiftly, before I hand over to Senior State Counsel Munene Wanjohi, I want to recognize the presence of Major Murunga from Firearms Licensing Board Secretariat. Karibu sana. So over to you, Bwana Munene.
Okay, thank you. Allow me to talk with a stand. I don't like speaking when I'm seated. So thank you people for having us here. Thank you, Senior Counsel, for that wonderful presentation. At least now we are learning to know that now we have a firearm. Something has happened. you're taken to the police station, then you're presented to court. That is our senior prosecution counsel from the office of DPP, based at JKIA Law Court. We'll take you through the process of now you. Let's say, Karibu. Okay.
Thank you very much, Council. Members of the board present, members of Ngao, Senior Council, Wanochen, thank you for the presentation. So my name once again is Alan Mulama. As you've been told, I'm a prosecutor with the ODP, Office of Director of Public Prosecutions, where I mostly prosecute terrorism cases and drug trafficking cases. I'm currently based at the Jomo Kenyatta Airport. Hardly trained to face up with counsel like Mr. Ochieng in court, and therefore it was really an happy task for them, and we appreciate what the MPS did. So that's why we go on mandate to prosecute, and we do so now in all the 47 counties. So I'm privileged to be here. I've never been here. This is my first time. When Council Monene told me that I'm going to present before Ngao members, ordinarily in government, when you hear Ngao, I thought it's the national government administration officers. So I told him, and who are those people exactly? When he told me this is what happens in Ngao, then I said, okay, I think I've heard of Ngao. So thank you very much. So my presentation, I'm just going to, my outline will be that I'll take you through the Constitution 2010, just some provisions for which Council has been able to mention. I'll equally take you through the Penal Code, which I intentionally want to inform you that was enacted in 1930 by our colonial masters. We want to know that, and of course we have had some amendments along the way, but it's a 1930 legislation. Interesting amendments as firearm holders, it will be interesting. The most unfortunate of circumstances, and of course for civilians as well. So the Constitution, I'll be focusing on those four legislations. Of course, the list is not conclusive, as you've heard already. When you now come to court, we of course rely heavily on the Evidence Act to present such evidence in court. Maybe evidence from the ballistic officers. We rely also on electronic evidence if there's anything to do with electronic evidence, the Evidence Act and the Criminal Procedure Act. But I'll just now focus on the substantive law of what gives you the power or privilege, as I may call it, for you to have a firearm. So Article 2, which is the Supreme Court law of the land, and as you are all aware, the Constitution binds all persons and state organs. So that when you now move to that realm of being called a firearm holder, then you should, at the back of the mind, be aware that at the end of the day, you are bound still by the confines of our Constitution. Article 12, of course, Council mentioned it, on the rights, privileges, and you see I've intentionally put privileges in bold because for me, I think gun ownership is something that should be held very solemnly. We should not look at it, as Council said, as a walking stick or fly whisk. It is a solemn thing, and therefore, for me, it is a privilege. And with this privilege comes immense responsibilities, and therefore the need for restraint and discipline. Yes, so Article 19.3, now fundamental rights that belong now to each individual. Remember, this fundamental right, even to life, is not granted by the state. These are inherent rights that belong to each and every individual, gun holder or not. And all these sections or rather articles I'm focusing on, at the back of your mind, I'm driving to the fact that we are now gun holders. Therefore, we are at another level of society, a privileged class of society, if I may use that word, which comes with a lot of great responsibility. So, of course, Article 26, there are instances where the right to life can be limited by law. And we'll demonstrate to you that, of course, justifiable use of force is one of those instances where this right to life may be limited in such circumstances. Of course, freedom, the security of the person, and of course, protection of property under Article 40, right to acquire and own property. I think this is now the background where now, as firearm holders, you may want to feel that, yes, indeed, it has reached a point where I, in fact, need to secure my property, secure my life, and that's now why we focus on these Articles 29 and 40. Again, this Article 47, though you are now past it, but it's just with regard to fair administrative action. There's a plethora of cases where several gun holders have taken the board, to court for being refused licenses. So this is just one of the things that also, as a firearm holder, you should be aware of, because yes, in as much as you can apply, but it is not always that you will get, the firearm issued because of several other issues that we may discuss. And we have had instances where people have had to have gone. So Penal Code, Section 9 of our Penal Code, that is the intention and motive, and also accidental acts that happen out of one's free will. So that if you may be able to show that something was done accidentally or out of accident, then it might as well be something that can come in as a defense when you are caught up in some of these issues, as we discuss in some. So Section 17, defense of the Penal Code, defense of a person and property. And this is to be determined as per the English common law. And I'll also be discussing with you what our courts have said with regard to this right to, defend yourself and property, and the issues of necessity, as Council has pointed out earlier on. Section 18, again, of the Penal Code, very important for you guys, because this is now on the use of force, on effecting arrest, and the nature and circumstances of the offense. Even though we know police officers can arrest without a warrant, but you also know that as citizens, you can effect what is called a citizen's arrest. So in such instances, when is it that you can draw your firearm to try and effect such arrest? In what circumstances? What are some of these offenses? Someone grabs a phone in CBD and you are right there. Will you draw your firearm because you want to arrest this suspect? You might want to think about it. So these are some of the things that we really need to ponder even as we move on. So the Firearms Act, again, which will be sort of your Bible or Quran or Gita, Section 2 defines firearms, and you'll be interested to know that now in the Security Laws Amendment Act, Sections 36, there are now amendments that were brought in so that even mufflers are now considered to be firearms. Even silencers are considered to be firearms. Even night vision equipment. So that if your license reads that you have to have a certain caliber of weapon, and you are found to be in possession of a silencer, then you might be in trouble. These are amendments that were brought in by the Security Laws Amendment Act. These are some of the things you may buy, you may come across and you will think, okay, it's cool to have a silencer, why not? But you may want to think about it before you do that. Of course, Section 34 of the Security Laws Amendment Act again was also amended, and even having armored vehicle, you also have to be licensed to have an armored vehicle, because you may want to now move higher and say, okay, now that I have a firearm, why not? There are some of the things you need to know so that you don't end up importing a vehicle that will be stuck in customs for clearance and licensing issues. So, of course, the purposes of this act, the Firearms Act, you note, is to regulate the possession and use. Yeah, possession and use, because, you know, ideally, and for those who love philosophy, we live in an anarchical society. The society is full of anarchy. So if we do not control the excesses of man, then I think, as one philosopher said, that our life will be short, brutish, and nasty. So we have to control each other's excesses, and that's why we have some of these laws to sort of curtail us and put us in check. So Section 4.3 of the Firearms Act, of course, prohibits the possession of some prohibited weapons and ammunitions. And also, you want to know that you are not allowed of what, or in excess of the quantities that you are permitted at the time that the license is enforced. You don't want to exceed that, even by one. And the offenses here can range from, the punishment here can range from anything to 7 to 15 years, depending with the ammunition or firearm that you have been found with. Section 4A of the Firearms Act, which again was an amendment, 2010 amendment, it will be interesting to note that it is only after 2010 that now government agencies now recognize that we need to have a class of weapons, specified firearms. These only came in after 2010, so that the MP5, the AK-47, G3s, and these are high caliber weapons. You know you cannot possess them unless you work with some other agencies, or you have some other tasks that you are, of course, undertaking. Section 5, these are, of course, application for grants and licenses. And these are some of the things that I know you went through, and of course you are past that stage. But of course, there's something that you may want to note in those applications. What the board considers is that if you are of an intemperate habit or of an unsound mind, then you are not supposed to hold these firearms. And from what you have seen happening, the road rages and people going to these nightclubs with the firearms, you may want to question whether they are intemperate or they are sound mind, with some of the things we have been seeing lately. Of course, it's an offense under 11A of the Firearms Act to have a firearm with a serial number that is obliterated. Because once the serial number is obliterated, the presumption is that you want to use this firearm to perpetrate some illegal, I have had to prosecute a person who had an obliterated firearm, AK-47, and this fellow was jailed for 15 years. Simply because when this firearm is taken for forensics, there has to be some methods other than the usual ones taken so that you can be able to lift that serial number and see whether it has been used, whether the firearm has been used to commit other offenses. Therefore, even as you are a firearm holder and you realize that could be out of use, wear and tear, the serial number is somewhat becoming obliterated, you may want to report this at the earliest so that you can see how that can be sorted out. Because once you're arrested with that, the presumption is that this firearm has been used for some other unlawful purposes. Of course, pawning is not allowed, and taking of pawns. We live in a world where people want to get rich and people want to engage in betting, and therefore you should not go somewhere and horse races and bet and you pawn your phone or you pawn your firearm. Or if you are engaged in that business, you accept a firearm to be pawned to you, it is an offense. Of course, you are obligated to immediately, the soonest possible, and you see that is now subject to interpretation. What is the soonest possible? The soonest possible, you notice that your firearm is not with you. You've lost it. It is your obligation to report. Failure to which, it's an offense. So again, it's now for you to judge what is the soonest possible, right? I had a case where someone lost a firearm, he never reported. He actually lost in court, he never reported. This firearm was used in a robbery incident like 3-4 years after the loss. And when the firearm was gotten by the officers, when now they ran it through the database, it was found that it had committed several other offenses. This firearm holder was now linked to these offenses, whether he was at the scene or not. So, soonest possible report. Don't catch a sleep if you lose your firearm. You've been told you won't sleep either way. So, yeah. So, of course, issue of drunk and disorderly, and while carrying a firearm, it is very rampant. You can see the penalty there. Not more than 1 year or 10,000 shillings. To me, it's a slap on the wrist because firearms are not sticks. They are not cooking sticks. You know, they can cause anything from grievous harm or maim to killing someone. Therefore, you can see our laws somewhat, we may still need to think about them because we see nowadays people flashing around their guns, you know, and at the shortest of opportunities and incitement, they will pull out their guns. Even for a simple traffic infraction, someone will pull out their gun. It happens in Nairobi. We really need to think about our laws and whether we need a case for amendment. So again, imitation firearms. If you are a firearm lover, you may want to be a bit creative. Please don't be creative and start modifying your firearm and start to imagine other things other than what is appearing on the license. Because I know some enthusiasts might want to think of some very creative ways of having or possessing some of these arms. Of course, you'll also want to know that it is illegal to own a bulletproof jacket, vest, helmet, again, unless you are licensed to do so. Yeah, so self-defense. There is an interesting Court of Appeal decision. This is Ahmed Mohamed Omar and some 5 others versus Republic. It's a 2014 this Court of Appeal case, okay, where now the court laid out the common law principles that I had referred to you earlier on what entails use of force and self-defense. It's on and off, yeah. So the courts had this to say, Court of Appeal judges, that it is both good law and good sense that a man who is attacked may defend himself. It is both good law and common sense that he may do, but he may only do what is reasonably necessary. Necessity comes in. But everything will depend upon the particular facts and circumstances. Some attacks may be serious and dangerous. Others may not. If there is some relatively minor attack, it will not be common sense to permit some action of retaliation, which was only out of proportion to the necessities of the situation. If an attack is serious, so that it puts someone in immediate peril, you are in immediate peril, then immediate defensive action may be necessary. Interesting passage here by the Court of Appeal. So that issue of necessity comes at hand. The issue of proportionality comes at hand. So that, one, is it necessary? And when it becomes necessary to draw your firearm, yeah, charge it and put your finger on the trigger, then is that action reasonable and proportionate in the circumstances, noting the risk at hand? This is what the Court of Appeal had to say, and you may find some time to interrogate and read that authority. So the last line, I don't want to bore you with the authorities, but just for you, you can have a feel of what our courts think about this whole thing about self-defense. The defense of self-defense either succeeds so as to result in an acquittal, if it's disproved, in which case a defense is rejected. In a homicide case, the circumstances may be such that it will become an issue as to whether there was provocation, so that the verdict might be one of manslaughter. You see, so that the court is trying to say that if you are provoked, then if it were a murder charge, and you have raised the issue of self-defense and the fact that you are provoked, then of course the charge may be reduced to manslaughter. But again, you may want to know that even for manslaughter, still it carries up to a life sentence. And therefore you don't want to get yourself into such negotiations with the law as to whether it is a murder or a manslaughter. And again, still our courts have said, even if you are provoked, what time will it take a reasonable man to cool down from the flares of temper? Still the courts have said that, right? Whether it's an objective, subjective case, it will depend on the circumstances of the case. So that if someone were to come, the common cases we have, you are drinking at a pub, the case about Munene's son, where also Alex Chepkonga was also charged, but later on acquitted by the Court of Appeal, the one that senior counsel mentioned. They were provoked in a bar, right? The bouncers came in and separated them. I think that was at Crooked Q in Westlands. They were separated by the bouncers, who did a marvelous job in trying to quell, because they were all raring to go, both factions. And what Chepkonga and actually the first accused was an officer. What he did, this is a guy called Dixon Mwangi Munene. Munene was an officer, and Alex Chepkonga. 2014, again, Court of Appeal Authority. Alex Chepkonga was acquitted. But Dixon Munene, who was actually armed by the time they were going to the bar, and you remember they had drunk from the previous day from about 6 p.m. to the following day at about 6 a.m. It was a drinking spree. And Munene really had a difficult time convincing the courts that even after they were provoked, 30 minutes after, he had to corner this guy who was now defenseless and shot him. You know, the conviction by the High Court was upheld for Munene, even as Alex Chepkonga walked away. And remember, Alex was not armed. It was Munene's firearm which was used. So again, you see, even as firearm holders, you have always to think, what are the consequences that you as a firearm holder may have on your immediate family? Someone who's accompanying you in your vehicle, you get into a road rage. You see, they were charged together. So you may also want to think before you act as to what are the likely consequences. Yeah? And this is such a case where the court said, what is the reasonable time a man may have to cool down? Yes, you are provoked. It is a given. We agree you are provoked. This guy slapped you. And actually, I think he asked, the deceased walked up to where Munene and Alex Chepkonga were drinking. And he tapped one of Alex Chepkonga's friends and asked him whether he was gay. They didn't take it lightly. Yeah, and they were drunk. Remember, they were drunk. They didn't take it lightly. That's how this thing went down. So you want to think, yes, you have been provoked. Learn to walk away. Right? Always learn to walk away. And I always say that people react differently. And maybe you'll agree with me. Before you were armed, and after you got a license and you are probably now armed, more often than not, you react differently to circumstances. More often than not, right? So always learn to exercise restraint, always learn to walk away. Don't wait to be provoked until the court comes to say you had time to cool down, but you reacted. Don't wait for that argument in court, because it can go either way. So yeah, sorry, just a minute here. So if self-defense was raised as an issue in criminal trial, it must be disproved by the prosecution. So that if you are to be accused of misusing your firearm, then you raise that defense, that indeed I was trying to defend myself, all my property, or someone else's life, then it is now upon us as a prosecution to dislodge that defense, maybe by way of other evidence to show that no, you had time to walk away, or the deceased or the person who was injured was fleeing and you shot at the back, or maybe you expended 10 out of the 15 rounds that were, in the magazine, that kind of thing, to show that now it is no longer provocation. This was something else other than provocation. This is because it's an essential element of all crimes of violence that the violence or the threat of violence should be lawful. In such cases, the prosecution is enjoined to prove that the violence used by the accused was unlawful. Yeah, because remember, for murder cases where guns are used or anything else, but now for this case, guns, we usually charge under section 203 of the Penal Code, as well as 204, where we say that you unlawfully, so-and-so on this day, unlawfully caused the death of so-and-so. So, in as much as you'll be trying to tell the court that I was acting out of self-defense, I was trying to protect my property, there was an accident and border riders all of a sudden flooded my car and started, I had a small child there, 2-month-old baby, maybe my pregnant wife, myself, and they were all over us, and I was trying to protect property and life. It will now be upon you to show that, in fact, that death was not unlawful, but it was actually lawful out of self-defense. Okay. So yeah, we have the case there of Dixon Mwangi, Alex Sepkonga, the one for the Crooked Q Club. Interesting read for a gun holder. You may want just to read this one to see what the court says on issues of self-defense, provocation, and those kind of things. Then, of course, some, again, not very good examples, because these are examples of people who we are called honorable, but unfortunately, they don't carry themselves in such manner. The DJ Evolve incident, where Babu Wino was involved. Didimas Baraza case in Bungoma, again, use of firearm in the most bizarre of circumstances. The Senator Njoroge shooting incident, you remember, where Polycarp Igade was involved in Naivasha. Again, quite crazy, but of course the senator said, and by the due respect to the senator, and these are just examples. He says that you see I'm disabled, so when I'm provoked, the only way I can react is whipping out the firearm. And somewhat the matter was settled, and the senator got away. But of course, a few months later, another incident in Machakos. So you may want to think whether we need to review some of these licenses. Last authority I may want you to share with you again is Victor Nthiga Kiridu versus Republic. Issues of self-defense. So self-defense, as the term suggests, is defense of self. This is what the court had to say. It is use of force or threat of the use of force to defend oneself, one's family, one's property from a real or threatened attack. Self-defense is therefore a justification in the application of force recognized by common law, right? But remember, all this is looked into in light or in the prism of the circumstances surrounding, the danger appertaining, the apparent risk. The law generally abhors the use of force or violence, but there are instances where a person is justified in using reasonable amount of force in self-defense if he or she believes that the danger of bodily harm is imminent and that force is necessary to repel such danger, meaning that force must be necessary and that it must be reasonable. So commensurate force in the circumstances. The danger that the accused apprehends, however, must be sufficiently specific or imminent, right? When you're given the example of someone who's 100 meters away, maybe fleeing, and someone who's within arm's length, you may want to think when you want to react. Not to say that you should always execute, if I may use that word, for someone who's within arm's length, not to say that, but you may want to think when and how to react in all of these circumstances. What amounts to reasonable force is a matter of fact to be determined from the evidence and the circumstances of each case, right? It is not always true that someone who's 50 meters away will not pose any danger. It depends what they are carrying. It depends what they have, right? So it always depends with the circumstances. Someone who's 50 meters away from you can be more lethal than the one who you're seeing seated here. So it depends with the circumstances. So these are some of the thoughts that I had with regard to the issue of self-defense. And now, of course, after having heard from counsel, some way forward to me, I think from the prosecutor's perspective, I think we may need to consider, of course, this may be subject to debate, but we may need to consider setting up of an independent firearms licensing, sort of forensic bureau, because you see, all offences now are investigated at the DCI lab, so that if you have an incident, it is dependent on what the investigators will say. We hardly get a chance where someone has gotten an independent forensic sort of analysis of their firearm. And we know that at times some of these analyses, they can be skewed depending on the circumstances and who's on the other end. And therefore, I think from the prosecutor's perspective, it is high time that now we may want to open up this field so that we can have, the same way we have forensics labs like Lancet for paternity tests. There's the government lab, the government chemist, and you can go to Lancet for paternity tests, and they're admissible in court. I think from our perspective, we may need to have this so that in those cases that, for instance, those ones of police excesses, and it is the police who are unfortunately, but of course, in the circumstances, they are the ones who examine those firearms, sort of investigating themselves, you understand? So, use of forensic psychologists to assess fresh applications and renewals. In my view, when I say that most of those where Shimiwas behave in some manners that are not very honorable, I meant every bit, because when people go for forensic psychological tests before they are given firearms, which I believe you all went through, the presumption is that first they have sound mind and their temperament is okay, such that they can be entrusted with a firearm. But what you have seen is far from the truth. And I actually tried once to apply, and when I was told, I never tried. So when I was told, I was in Mandera and I really needed to have one. And when I was told to go for a mental checkup, I went there because you see, as prosecutors, we always subject accused persons who are charged with murder for mental assessment. Traditionally, it's nowhere in the law, but traditionally that happens. Some people have contested it. But when I was told to go for mental assessment, I'd never gone there. I usually just send people there. So I went. And I met the doctor there, and he was sitting there with a pen and a notebook, and he asked me, what is the date today? Who is the president of Kenya? What is the time? Do you have a family? And he says, okay, fine, go away. I don't know if you had such a mental assessment. Was there any forensic about that assessment? Nothing. I think we seriously need to think about these mental assessments, specific for some people who want to be issued with firearms. Because I think we have so many madmen out there with firearms. Sorry to say, we have so many of them. Because it is a form-filling exercise. These forms, they are form-filling exercises. You just say, it's like ticking boxes. You need a bank statement, it's there. You need, I don't know what, it's there. You need, we just go through the motions. We seriously need to think about the mental examinations we do for firearm holders. So we need also to establish a firearms registration information system so that we can be able to monitor, because I believe for Ngao, it's good that we know you have your members and you can monitor them. For the Bureau, yes, you have the applicants, you can know Mulama applied on this date, maybe issued or rejected. But we need some real-time monitoring system, because there are people who apply for a firearm today, and for the whole year, as Wakili said, they have not fired a single shot. No proficiency tests. You see, like driving license, when you have a driving license, it's presumed that you will be driving for quite a, But you find that someone has a gun, they only come to renew after the year. You don't know what they've been doing these 364 days before they come to renew. I think probably it's something for law reform, but we may need at the end of the day to make institutions, to empower institutions like Ngao so that it may be at least mandatory for people to again go for refresher courses, to go for classes like this, because what happens is we just issue, but there's no proper way of monitoring who does what with their firearms. Then, again, from the prosecutor's perspective and from what I've seen happening, we forfeit every day lots of firearms, lots of ammunition, no guidelines on how to dispose them. There's a case I was doing recently, and we forfeited about 1,039 rounds of ammunition, some 5 AK-47 rifles, hand grenades, 36 of them, so a terrorism case. Up to now, we are stuck with those things because there's no specific law on how then do you dispose them. And this is the same problem we have in Africa, where now we have proliferation of these light weapons that cannot be accounted for by the state. So we may need to have a proper center to sort of monitor how forfeiture is done, because what we have seen instances of narcotics where bang is impounded and it finds itself back to the market. What more of weapons which can still be impounded, forfeited, but still they find their way back into circulation in the hands of the wrong guys. So there's need maybe to the board to come up, I'm not sure whether we have, with the reporting mechanisms and surrender for firearms of people who are deceased and people who are incapacitated for one reason or the other, out of ill health and any other issues. I don't know whether we have any, because what happens if a firearm holder, God forbid, drops down today, dies? There's no way the bureau will know. The board will know that so-and-so who was a firearm in northeastern Kenya passed away. What happens to that firearm before the license expires? Right? Right? Yeah, so we may need to have maybe proper regulations as to what should be done in such instances. Yes, so I think that is, those are the thoughts I had today. And sorry to say, I was sent here by my supervisor, Mr. Sang, who was to be here, but he had travel outside the country. And therefore, on some very short notice, I had to come. I hope I have attempted to fill into his shoes. Thank you. We'll now take any questions. Yeah.
Thank you very much, Alan Bolama. Take on from that is always run away when there's an opportunity. You see where because you have your handgun strapped around you, you're going to look for the fight. And also one other thing that Mulama has said, all these rounds that we carry from the range that are not authorized to be in your book, in case of anything, we are going to be in trouble. And unfortunately, many of us always do that. It's a good thing to make sure that...
Actually, and even leave alone live ammunitions, even cartridges. It's an offense to be in possession of cartridges. So, yeah, so be careful here.
Thank you for that. So you hear even cartridges can be an issue. That's very important. And also, finally, Tony Wahome, can you start your own lab, forensic lab? Yeah, because we only have to rely on DCI. So, yeah, it exists. Are there?
Sorry, perhaps for introduction. My name is Anthony Wahome. I'm a forensic ballistics expert. I worked with DCI for 10 years. But I run a lab. I give evidence in court, mostly for the accused persons in use of firearms. So yes, we are running independent examinations. Thank you.
Thank you, Wahome. Many of us didn't know, I actually didn't know that you have a lab. Without much ado, let me hand over to Monene. The skies are opening, but I believe we shall proceed.
We have some questions. We take them now or later?
I would propose, I'll do a small session on the powers of the board, the subtotal of the board. In case you have any question to the board, then you can address it to us. So as I said earlier, my name is Munena Wanjohi. Professionally, I'm a lawyer. I'm an advocate by profession, a state counsel. But at the board, I sit representing the Attorney General in the board. So the board is established under Section 3 of the Act, and it has 7 members we have 2 representatives from the National Police Service, 1 representative from the Attorney General, who is me. I hope you can hear me. Then we have 1 representative from Private Members Group, who is Mr. Chengo, your chairman, our chairman. 1 rep from KWS, 1 representative from NNIS, and 1 representative from National Focal Point. So the powers of the board are under Section 3, subsection 5. And number 1 is to certify suitability of applicants and periodically assess proficiency of firearm holders. So when you applied, you had to be vetted. You came to the board for a short interview. God is good, you passed, you got the licenses. Number 2, which is very important, we issue, we cancel, we terminate, we vary any license in matters pertaining firearms. What do I mean? Now you are issued with a license. If tomorrow we went to Kikau and you misbehaved, we can cancel that license. Number 3, if you want to vary that license, for example, you have a SESCA, then you want to have a Glock, we can vary that on application. But now we call it one-on-one. You deposit the old SESCA, then you purchase a new Glock. Number 3 is that we register civilian firearm holders. We have a register of all of you people. Number D, we register and supervise and control all shooting ranges, including this one. So this one is, I can tell it is licensed to operate. Number 3 is to establish and maintain a centralized record management system. Major Murunga here, if you give him his number, your number, he can tell you whether you're licensed or not. So that is the power of the board. We are located at industrial area, Mbigwani Road. There's something I want to talk about. The rain. You can still hear me? Very well, very well. So there's an issue of the annual renewal of firearm licenses.